Professor, tell me about the Loper Brightite case.
Sure. So Loper Brightite is the case that overruled the Chevron doctrine. And the Chevron doctrine originally required that if there is an agency statute that governs an agency's conduct, the agency gets deference, meaning a thumb on the scale, when it's interpreting what that statute might mean as it's carrying out its duties. Loper Brightite determined that that framework was inconsistent with the Administrative Procedures Act, and instead that moving forward, courts should decide all of those statutory interpretation cases as a de novo matter, meaning the agency doesn't get any sort of special head start.
How much deference did a federal court have to give to an administrative agency under the Chevron doctrine?
Sure. So the court would originally make a step one determination about whether the statute was ambiguous or not. That's in the eye of the beholder sometimes. But if the court determined that the statute was ambiguous in the relevant sense, meaning it didn't resolve the question the agency was facing, it would defer to the agency's view of the meaning so long as the agency's interpretation was well explained and reasonable.
What's the relationship, if any, between Loper Brightite and West Virginia v. EPA?
So that's a fascinating question. I think, West Virginia versus EPA applied Chevron, but said we're less likely to find ambiguity, and indeed Congress needs to speak clearly if the agency is purporting to resolve a matter of, in the court's terms, political or social significance. And following Loper Brightite, of course, there is no deference. And I think some have commented, including Justice Barrett, that the best way to think about West Virginia versus EPA in interpreting statutes is that it informs the context of how we understand what the statutory terms mean in the context of an agency delegation. So the fact that the agency is purporting to carry out its duties might resolve whether or not the particular question is sufficiently clearly delegated by Congress.
That just seems to me like a distinction without a difference. I mean, doesn't Loper Brightite wipe out the need for West Virginia v. EPA? Why do we still need a major questions doctrine?
So it's certainly true that West Virginia versus EPA, I think, was partially driven by non-delegation doctrine concerns and concerns about deferring to agencies when doing so threatened our separation of powers. After Chevron has been overruled, of course, that might be relevant in a smaller number of cases, but I do think that the major questions doctrine still has vitality in understanding the best meaning of the statute as Loper Brightite now requires.
What's the public rights doctrine?
So most recently, the public rights doctrine has been applied in the Seventh Amendment context, and the Supreme Court has a decision named Jarkissi, where there's a line of precedent saying that if a matter involves public rights, so the conferral of a public benefit, for example, that might be the type of matter that Congress can vest adjudication of in Article I tribunal or in an administrative agency.
What's a public right?
That's a very difficult question to answer in many cases.
That's why I'm asking you.
Yeah, so I think the best way to think about it is to contrast it with private rights. And what the Supreme Court has instructed with respect to private rights is that they're what we would think of as common law type claims. So contracts, property, torts, the stuff of Westminster in the court's terms. And so if you have a matter like that, that's the type of matter that needs to go before a jury to ensure that the Seventh Amendment's jury protections are abided. By contrast, if there's an internal administrative process, Social Security benefits, things like that, that looks more like a public right that wouldn't have existed but for the government granting it.
And what did the Supreme Court hold in, was it Jarkissi?
That's right.
What did the Supreme Court hold?
So the Supreme Court there held that certain matters of the Securities and Exchange Commission actually looked more like common law fraud claims and more like property-based claims that must be tried to a jury in court and cannot be vested in the in-house SEC proceedings to be tried before an administrative tribunal.
My time is done. Thank you, Professor.
Okay, against my